Yes, class. Now we are going to be discuss about the software patents, and that's your final uh, last number three video of week 10. Here will be understand about the software. Is our software will be patentable or not, and how we can patent our software. Especially you guys are basically belong to the computer science study, and in future, inshallah, hopeful you will make some software and doing work with the and some software industry. Then you will be know about the better know. You have to be understand how you can protect your software with the patents, and are their software will be applicable for the patent or not. Okay, now that's a general discussion. We just start software patent. Like a software patent is a patent that protect the computer software. Okay, just wait. I am going to be select some yes material. Yeah, here an software patent is a patent that normally protect the computer software, and the software patent that can cover the standalone the computer software program, mobile device application software that is integrated in a mechanical device. Okay. In order to software to be a patentable, it must be meet the same requirement of any other type of invention like copyright and other thing. In a particularly software invention must be the new. It will be a useful, new, and a non-obvious that you will not be a copy and a theft thing. Okay. A fourth requirement is the one of important that invention be type that is eligible for the patent protection. Okay, mean to say while an last requirement applies to the all invention. The question is again in the mind that invention is it is an inventionable and it will be eligible. Okay, it must be a more impactful to the software invention that is the other type of invention. Fine. So there is some points that will be introducing the software patents and we providing some index how we can write on a software patents and found on the BIIT websites, and that will be providing information is the software is a patentable or not, should you do protect software with a patent or not, and is our my software invention appropriate for the patent protection and not, and how we can realize the that's my software will be patentable, and how I can protect, and some provisional patents grants on the computer science computer software. Okay, that is some website and some BITLA website that will be providing some information related to the software patents. Fine. On the next slide, we will discuss their detail. Yes. As I discussed that we will be discussing about the software as a patentable node. Okay. Just I'm going to be clear first. Yes. Now it is now first thing that our software is a patentable or not. It is now well established that many type of computer software, including the mobile application, can be protected by the patents in the United States. But this has was not always the case. That United States Patent and Trademark Office originally decided in the 1961 that computer program will be generally unpatentable. Okay, but further, the Supreme Court considered that the issue the 3 to 4 times in 1970s and further in 18. That seemed to agree that patents and the trade officers decided that software was unpatentable, but the software now the position that whenever you will be copy the code and program, and because then further 1990s it will be assumed that software will be protected produces as a useful result, and it should be a fulfill the requirement and should be a patent requirement, so that the especially in the 2000 Alice decision in 2014, they will be court then will be decided that software should be a patentable. And now the current situation is that again the software is a patentable, but only that software will be it will be a direct or abstract idea, and then it will be a patentable. Okay. So the some expert, if we talk about the thing that in historical, I'm discussing about the 1960s and 1970s, 2 and 3, and the last 15 years, 2 times United States will be decided, court decided is unpatentable, but further then will be after a 10 year will be proceeding, especially in 2005, 14 and 2000 software should be a patentable. Reason is that because it should be a patentable in common sense, uh, developers and companies have some need to be bear some cost, their research and their effort, so that it should be a patentable. Like the some software expert think that too many software patents are being granted, and they believe that there is a enhanced to the new software development. Indeed, each new software patent lawsuit add to the cost and the business risk associated with the software development industry. And software patent battle, that's uh, some examples I want to discuss among some of the biggest names, the in a software industry, but they are so some facing some patent battles and get us some loss because they are just copying and using their ideas and not be registered as a patents. Okay, and next we will discuss it. Yes, student. There is a patent battles among the companies that you are already familiar the name, just like Oracles and Google's. That's the battle over the patent infringement claims and associated with the Oracle Java programming language. Okay, with Oracle sinking $6 billion in the damages. Oracle faced this. Okay, and similarly, if we talk about the uh, I mean, Apple and that Apple sued the Samsung for the patent infringement regarding to the several patent association with the Apple smartphone and tablet devices. So the Apple was ultimately awarded 1.1 billion in the damages. Okay. The further is the M Formation, a global provider of a mobile device management technology that's awarded $1.147 million when it issued uh, research in the motion for the patent infringement of M Formation patent technology, which enable the company to remotely access the employee's mobile phone to perform software upgrades and changing password and erase data. Okay, that's some M information we have offered, but they the sue against the other companies and get the some awarded amount and recovery their damages behalf of the people and other company are copying and destroy their customers. Okay, these are some names we discussing about the uh, battle of our software patents. Fine. Now further, we discuss about the cross license agreement. Yes, cross licensing agreement. What is this? Cross licensing agreement is a basically many large software companies, have cross licensing agreement, and they are opposing to this agreement in which each party agree not to issue the other over patent infringement. Okay, for example, like the Apple and HTC battle for several years over a previous mobile phone technology related patents, okay, which eventually led to the United States International Trade Committee banning import of the two model of the HTC mobile phone. The two companies eventually agree later on to the 10 years cross-licensing agreement that they permit each party to license the other current and future patent. They will not be battle and they do their work. Okay, that is a some cross-licensing agreement concept that the people are basically companies are now the agree and they will not be used for the any software patents in fragments. Now the further things that is some examples we are discussing. Now further we will discuss about the how the protection of software with the patents. Again, the patents on a software invention were are not a different than other patent. Okay, and that's mean to say obtaining patents grants certain that have some right to patent holder, namely the exclusive right to make, use, sell, and the import your invention. That's the right of a patent holder. Look like other copyright and trademark. Similarly, patent holder who are basically make and their effort who need to be grants, they have a right to give the other companies and that sell their patents, make some how use the allowing the give the permission that have a rights. But these rights are described in a detail you need to be rights granted under the United States patents law. Uh, that's law are basically providing how the significant cost you will be bears and you obtain these right only after a significant cost, and only that's after the application will be examined and patent office are agreed upon the patent should be granted on an invention. Before the patent issue, you have to write to publicly state that your software is a patent pending. Publicly, you can announce it, but as the cost and the timely delay the filing and the patent application against the benefit of the patent pending, the right obtained when the patent issues are discussed here and when the time you need to be decided that you will be give the permission to other parties and the other people and that the time to will be safe. Okay, if we talk about the file patient application, that's the important thing because the patent application and patent uh, information that is protecting software that again look like a copyright protection that automatically granted to the software upon the creation or a fixing. Okay, and the new code, but the right granted under the copyright law are limited to the copy of a computer code, not a whole one. Similarly, whenever the steal your ideas, your patent application will be proceed further. Okay, if we talk about the patent requirements, and that's again that's something additionally, however, software must be eligible or not. It is will go slowly directly to the abstract idea or not. Different section will be provided, like in the United States mark in section 101. That will be that again. I'm talking about the BITLA websites material. They are providing the section 101 index. That index are related to the material or a BITLA and section 101 rejection. How it when it will be rejected, that's a good introduction to the issuance and rejection and the PTO mean to say your patent and trademark office's current approach and the issuing section and overcoming the section rejection. That's all are even your software is a new and useful and a non-abuser, but that should be the eligible under the section of 101 or not. Okay, that is some formality that will be you need to be learned and you be utilizing is their software be applicable for the patent or not. Okay, that is some things that lawfully things. Now I'm talking about the protection software with the patent, but how you will be procedural judgment mean to say how you will proceed the patent application, and how we will be able to learn about the patent application to be filed, and some if the patentability research or not. Okay. If you want to protect your software through the patent system, again, we and company and you must to be the submit a patent application. Again, that's the one of the important thing, and your application must be the describe your invention and in detail. These are specification, your name and the rights. That should be include the drawing and the must truthfully names the invention of the inventors of the invention. Okay. These aspects of the application are describing here the patent application, you may the wonder where you have the develop your software significantly a file application. That's the one of an important application in a United States. First to file the country and then mean to if it two people separately invent same the invention or not, then grant the person that is a first to file. Okay, if the people are two people and the three people are basically using the same methodology and applying this, but who one of the person who will be applying the first application date officially, then the patent will be that's have a patent rights. Okay. In addition, you must file your patent application with 1 year of your first public disclosures or offer to sell your invention. Okay. You maybe you do not need to be create your software invention before you file your patent application. And then a further thing is that when should a patent application be filed? When should the patent application be filed? Normally, no, that is basically your, you can say, popular belief that is a non-necessity to search your software invention before you file a patent application that is it is already exists in the market or not. But in some cases, we may even the wise to skip doing the patentability research, and you should be uh, uh, read the following to understand better when doing a search makes sense and when it can be skipped. Okay, but the file should be your application should be filed. Okay, and should you contact the patent tablet search, and why not? Okay, the another thing patent application, I'm already discussed with you people. That's the one of the expensive thing with a software application typically cost between to 10 to 15,000, but maybe the now the it will be revised. In cost of filing application is not the end of the cost. It is just 4,000 will be have to be spent before patent are issued. That is the just filing cost. Okay, that breakdown of the cost is the presented different time. Okay, the patent application cost it will be depend. It make a sense to delay the cost be filing provisional application, which is the describing in the normally in different, and that will be a basically look like your budget and updated on the later on. Okay, the United States and a different company are going to be updated on the time to time. Fine. Now, if we talk about the provisional patents on computer software, and that's a concept that related to again the cost of drafting and the non-provisional utility that already I discussed in you on the filing time. Because the cost of drafting is a non-provisional utility patents, application is so high if frequently make the sense to start the patent process by filing an provisional patent application. A provisional application by itself will never become a patent. Rather, a provisional application act as a placeholder, and that's within a 1 year you will be replace your provisional application within a full cost non-provisional application. Okay, but the provisional application you don't be that it will be actually just for the same saving any money in the patent procedure, since the provisional application has to be replaced by the full cost application within a 1 year. That is just provisional application you are publicly announced to the I mean to say extremely that a provisional application that can be the extremely useful way to delay the high cost of drafting a non-provisional application. During the 1 year period, the inventor can produce and market their invention just and develop a much better understanding of whether the invention will be the profitable before full cost of a patent application is incurred. It will disadvantage just inventor and a patent holder just know about the idea of the market is their patent rights and their invention will be uh, profitable or not. Okay. Okay, class student, that's the provisional patents on a computer software. Now I'm going to be end this session, and our weekend lesson notes will be complete right now, and in further, inshallah, we will be start our week 11 material. Take care. Allah Hafiz.